I'm Advocate Nikita Pandit and I will be speaking on the assignment of copyright in India, and you're watching Legal Bytes. The main objective of this video is to understand how the owners of the copyright works can transfer their works to someone else, that is, assignment. So assignment in simple language is giving your property to someone else by an agreement, where the rights of the owner are transferred to whom the property is assigned. So the person who transfers the work is called as an assigner, and the person to whom the work is transferred is called as an assignee. Section 18 of the Copyright Act 1957 provides for the right of the owner of the copyright to assign his right to another person. Now he can either assign full work or a part of the work can be assigned to another person. Such assignment can be done for the whole period of copyright, that is the lifetime of the author and another 60 years after the death of the author, or it can be made for a part of a period as mentioned in the assignment agreement, that is 2 years, 5 years, 10 years, 20 years. If nothing is mentioned in the terms of the assignment agreement, it is considered that that assignment is made for a period of 5 years. Now, in case of territorial operation of the assignment, if at all nothing is mentioned, it is considered that it is entire Indian territory. The owner of the work can also assign the future work that comes into existence in future. But the right in that copyright will be transferred only when the work actually comes into existence. The assignment of copyright does not apply to the mode or the medium in which the work is communicated to the public, which was not available in reality or which was not used commercially at the time when that assignment was made. Unless there is specific mention of that mode or the medium in which the work will be existing, such mode or medium does not form a part of assignment. What is mode or a medium? It is the way in which the work is communicated to the public. For example, the reels for showing a movie in a theater. It may be a CD or a pen drive which is sold in the market. So it is the way in which it is communicated. The Act has made a provision when the authors of the literary works such as books, journals, magazines, and of artistic works like paintings, sculptures, they give their works for incorporating in a cinematographic films, they must not do away with their right or assign the right of getting the consideration for their work in the form of royalty, and that too on equal basis as that of the producer. The only exception is that the right of communicating the work to the public, which rests with the producer of that cinematograph. The exception to this is that the owner can enter into an agreement with the legal heirs or the copyright societies to make them collect the royalties. But any agreement which denies the right of collection of the royalty is void, that it is not legally binding. The same rule applies to the sound recordings where such literary or artistic work is used, but it is not a part of cinematograph. Here, the assignees are the ones to whom the rights are transferred, and if they die, the rights will be taken over by their legal representatives. There was a case, Saregama India Limited versus Suresh Jindal. Saregama used to record sounds, music, dialogues by making contract with the producers. These music, dialogues and songs, they become a part of the movie and the copyright rests with the producer of the movie. What Saregama claimed was that the right of the producers were transferred to them, and so they made copies in the form of cassettes and records. They claimed that the music company owned the copyright in case of movies like Rajnigandha, Shatranj Ke Khiladi and Katha. Now the rights in the first two movie records, that is Rajnigandha and Shatranj Ke Khiladi, were assigned for the unlimited time. But Saregama claimed that the rights assignment was not mentioned in case of third movie, so it was for unlimited period. The court interpreted the contract in a way that since there was a mention of 25 years in the contract somewhere, there was no doubt that the assignment was not made for unlimited period. Now this case arose because of the non-payment of royalty by the respondents to Saregama for a long period of time. So the court ordered that the royalty must be paid to them as the assignment is for 25 years and that is absolute. The parties decided to settle the case, but the court passed the order as far as interpretation of law was concerned. Now section 19 gives certain provisions about the agreement of assignment. The assignment of copyright requires that the agreement should be put on the paper in writing and it must be signed by the parties. Such agreement must consist of the proper description of the work which is assigned and or to be assigned, and which rights are to be transferred, for how long they are transferred, and the amount of consideration including royalty or any such agreed consideration. If both the parties agree, the agreement can be altered or stopped anytime as per their mutual understanding. It is of utmost importance that the assignees utilize the work and exercise the rights of assignment within 1 year. And if they fail to do so, the assignment gets cancelled if there is no specific clause in the agreement that mentions the contrary clause, saving the assignee from the non-utilization of the work. Now, if as aforementioned, the owner of the copyright makes an assignment to the copyright society where he is the member and then makes another assignment to someone else in contradiction to the terms of the agreement which is made with the society, the later agreement becomes void. Section 19A provides for the dispute settlement mechanism in case of assignments. If the rights assigned to the assignee is not exercised by that assignee, the assigner can approach the Copyright Appellate Board, but it is a rule that assigner should go to the court with clean hands. He should not be the reason that the assignee is not able to exercise his rights. Even if there is any dispute regarding the assignment of copyright, the complaint can be filed with the appellate board and the board can order the payment of royalty to the assigner. The revocation of the assignment can only be ordered by the board if there are arbitrary clauses in the agreement against the assigner. Now, in between the proceedings, the board can order the following terms of the agreement, but within 5 years, no order can be passed to revoke the assignment. The appellate board has been given a limitation period of 6 months to dispose of the cases. And if they are not able to do that, the reasons are to be given by them why they couldn't fulfill this provision of that time period. So these are certain important provisions regarding assignment of copyright. Thank you.